Our next presentation is new build contracts, U.S. versus European style. And as a chip off the old block, David Moss of Valley Moss, Rogers and Lindsay, a name we know very well. He's an associate there in Palm Beach, where he focuses his practice on yacht transaction. David Hull received his law degree from the University of Florida. We have another Gator in our midst. And with that, I'd like to ask you to have a welcome for David Moss. Thanks.
Good morning. I'm going to talk about shipbuilding agreements, particularly differences between U.S. and European shipbuilding agreements. And what I'm going to do is I'm going to start by giving you a little bit of background on these agreements. Then I'm going to walk through some of the typical provisions, and then I'm going to focus on a few particular provisions that tend to differ between U.S. and European shipbuilders. These are typically very heavily negotiated agreements. There are standard forms, but they are rarely used. That's less true with smaller production boats, but when you get into semi-custom, custom, and obviously the larger European yachts, these contracts, everything's up for negotiation. And that's typically a very sort of long process. Often on a larger build, it starts with a letter of intent, and then we negotiate the contract with the yard, while the owner's technical advisor develops the spec with the yard in parallel. And we have to sort of keep in touch to make sure that things that are changed in the contract are picked up in the spec and vice versa. And then when we get close to execution, take one final look through everything to make sure it's consistent. So it can be a very, as I said, a very long process of back and forth with the attorneys for the yard. Some yards have in-house counsel, some yards have outside counsel who negotiate their contracts, and some of them are based in the same jurisdiction where the yard is, and some of them are based out of London for European yards. So these are the provisions that we typically see. First, you have the description of the vessel, and that's not only the dimensions and type of vessel, but that's also the classification, whether it's MCA, whether there's a reference yacht to set a standard of finish for the interior. There's a payment schedule, which is usually a series of payments tied to construction milestones, and then a procedure for verifying that those milestones have been accomplished. There's provisions for an owner's representative. On a smaller build, oftentimes there won't even be an owner's representative. The owner will be making all the decisions about the build himself, but on a larger build, typically the owner appoints somebody with some technical expertise to make decisions on his behalf. And in fact, the owner may even have an individual or a team who are on site throughout the build, monitoring the progress of construction and making sure that everything's in conformity with the spec and that they're in touch with the builder, as well as the classification society and the flag state. Sea trials and acceptance are a very important part of every shipbuilding agreement. It's something that oftentimes there's some provision for that in the spec. And sometimes the builder will say, well, there's no need to cover that in the contract. The spec says everything about the sea trials. We prefer to have it spelled out in the body of the contract. So there's usually a process where they first notify that there's a certain date the sea trials are going to start on. There's an opportunity to inspect the yacht before the sea trials, do a walkthrough, and then there's a complete sea trial with a protocol of tests and measurements. And the owner then has some set period to deliver a list of defects or nonconformities, and you sort of repeat the process again until the yacht is in satisfactory condition. Now, oftentimes on larger builds, you have what are called permitted nonconformities. So you have a definition of certain nonconformities that don't affect the safe operation of the vessel and that cost in aggregate some less than some number to correct, and those can be corrected after delivery as warranty items. Whereas anything more serious than that has to be corrected as a condition of delivery. And the reason you don't sort of repeat that process ad infinitum of correcting defects is there's a fixed delivery date, and if the builder misses the delivery date, there can be serious consequences. So delivery, typically just that deals with not only the procedure for closing and transfer of possession of the yacht, but also the things that the builder has to deliver. From our point of view, the most important things are the documents and certificates that they have to deliver, from the regulatory bodies certifying the yacht's compliance. And that's another thing that sometimes they stick into the spec, and we like to move it up into the body of the contract so we have more control over it. Force majeure. As I said, there are binding delivery dates that have consequences. Usually there's some grace period of, say, 30 days, and then maybe 60 days of liquidated damages on a daily basis. So for every day after 30 that they miss the delivery date, they have to pay a certain amount, or a certain amount comes off the final installment of the contract price. And then beyond, say, 90 days or 180 days, depending on what we can get the builder to agree to, our client has a right to walk away, and that typically is the most powerful leverage that they have to ensure the yacht gets delivered on time. But builders are unwilling to agree to those sort of binding delivery dates with significant consequences unless there's provision for force majeure events, things that are beyond their control, whether that's storms, fire, and the definition of force majeure can be very heavily negotiated because obviously the builder is looking for the most latitude to be able to adjust the delivery date, and the owner wants to hold the builder tightly to the agreed delivery date. And so we usually put in provisions, for example, that any period of force majeure is waived unless we get notice of it within 10 days. So at least we know, and if we think that it's an illegitimate claim of force majeure, we have an opportunity to contest in a timely way the builder's claim of a delay in the delivery date. The performance warranties, most yachts have certain warranted characteristics, whether that's speed, range, draft, noise, and vibration, and there are liquidated damages and rights to reject associated with those. Usually the spec will spell out exactly how noise and vibration are supposed to be measured, the conditions under which you're measuring the range and maximum speed. But the contract will say exactly what the consequences are for the builder if they miss those targets. And again, that's usually some grace area, liquidated damages, and then ultimately, if it's totally outside what the owner is willing to accept, the owner has a right to reject. Title, which is something I'll talk about in more detail in a second. Who owns the boat during construction? When, if the owner owns the boat during construction, when do materials and components that are intended to be incorporated in the yacht become the owner's property? If the owner doesn't own the yacht, does he have a security interest in the yacht? If he does own the yacht, does the builder have a security interest in the yacht? These are all things that are handled in a section on title. Insurance is a major issue. The builder is going to carry builder's risk insurance to cover against damage or loss of the vessel under construction, but that's another thing that I'll talk about in a little more detail in a second. Taxes, I'll also talk about in a second, as well as warranty. That's obviously a very important part of the shipbuilding agreement, and I think we have a presentation on that later today. The default provisions, what happens if the builders default, what happens if the owner defaults? Usually the owner has a couple remedies if the builder defaults. The owner can get his money back. The builder's insolvent, that may be difficult. One remedy that we often negotiate is that the owner can simply remove the boat in its present state of construction and complete it somewhere else. And although that's typically more expensive, if the builder is unable to complete the boat as agreed, that's sometimes your only alternative. And you have to be sure that you have provisions that say, for example, that the builder will assign to the owner any agreements with subcontractors or suppliers or any intellectual property that's necessary to complete the yacht. So you really have to plan ahead for a situation where the owner has to remove the yacht and complete it himself. What does he need to complete that process? The owner's default, what we usually negotiate there is a formula for determining how much the owner is liable for if he becomes unable. I mean, the owner's default is almost always as a result of non-payment. That's really the only realistic way the owner can default. And so the builder will either complete the yacht or sell it in an incomplete state. Either way, their goal is to sell the yacht and get back their expenses, and there's some formula for determining how much the owner is liable for after they complete that sale process. Intellectual property builders are very protective of their intellectual property and the designs of the yacht. Also, on larger builds, it's not uncommon to have a naval architect or an interior designer who's involved who has his own intellectual property rights in the designs. But even if the builder owns the intellectual property in the design of the yacht and all the drawings and plans, the owner will need a license to that intellectual property just for the purpose of owning, operating, maintaining, repairing, and ultimately marketing the yacht, whether it's for sale or charter. So that license and the ability to assign that license to subsequent owners of the yacht after the owner sells it is something that's very important. Confidentiality is always important to our clients. That's always a balancing act because typically the builder wants to be able to advertise the yacht and show other prospective owners. This is an example of our work product. They'll want to enter it in shows and their industry awards, but we always need to protect the privacy of the owner. And I should mention sort of at the beginning that when I say owner, it's almost always an entity that's formed before or shortly after the individual owner enters into the shipbuilding agreement. And so we're worried about the privacy really of the ultimate beneficial owner at the end of the chain. The owner in these circumstances is almost always an entity. And law and arbitration is something I'll talk about in more detail in a second. Okay, so I mentioned title. The first thing, and in this part of the presentation, I'm going to sort of compare and contrast between U.S. and European builders. So the first thing about U.S. builders and U.S. law is that the Ship Mortgage Act, which is now part of the Commercial Instruments and Maritime Liens Act, does not provide for mortgages on vessels under construction. Under U.S. law, vessels under construction are not vessels. They do not become subjects of maritime law until they are launched. So you can't register a mortgage under federal law on a vessel under construction. So the result of that is that security interests in vessels under construction, they're not governed by federal law, they're governed by state law. And that state law in every case, in all 50 states, is Article 9 of the Uniform Commercial Code, which applies to security interests in personal property. You record your security interest in a piece of property in a financing statement that's filed in the jurisdiction where the debtor is organized. So if I'm representing an owner who's building a yacht in the U.S. and he wants a security interest in the yacht to protect his interests in the event the builder becomes insolvent, he will negotiate for provision in the shipbuilding agreement that gives him the right to that security interest, and then he'll file a financing statement in the jurisdiction where the debtor is organized. Now, sometimes there's a couple parties involved. There's a dealer and there's a builder. They may be in different states, and you can file them in as many states as you want, and oftentimes it's a nominal fee, and there's the more states you file in, the more likely it is that people have noticed that you have this security interest. An important thing is that you always want to perform a search, and you can do this generally for free on the State Secretary of State's website on the debtor to confirm that there are no earlier financing statements that cover the vessel under construction. So sometimes, say, they'll have a line of credit from their bank that covers all of the assets at a particular address or at their facility, including the vessel under construction. You will need to get an agreement from the bank agreeing to subordinate their security interest to yours to ensure that your client, the owner, is adequately protected and that he's secured in the event of the builder's default. Situation is different for European builders, and it does vary somewhat between jurisdictions. But pretty much all of the major European shipbuilding jurisdictions, the Netherlands, Germany, Italy, have some procedure for registering ownership or a mortgage in vessels under construction. In Italy, you go to the nearest harbor master, whether it's Via Reggio, where a lot of the Italian shipbuilders are, or elsewhere, and that's how you register your ownership of the vessel. Another thing you can do, some flag states, the Cayman Islands, for example, allow you to register the ownership of a vessel under construction. That's actually not really that useful for a client, because typically in a situation where you're worried about protecting your interest in a vessel under construction, those issues are going to be governed by local law where the vessel is. So in other words, if you're building in the Netherlands and a Dutch bank has a first priority mortgage on the boat, and you come in and say, my client has this Cayman Islands ownership registration, a Dutch court really is not going to care. It's governed by local law. So another alternative that European builders offer is you can get refund guarantees that are issued by the builder's bank that guarantee a refund in the event of the builder's default. Usually these are negotiated in connection with the shipbuilding agreement and attached as an exhibit for form. The important things here are the conditions for payment And typically that requires a final arbitration award, so they're not just going to pay upon demand. The owner shows up and says the builder defaulted, give me my money back. But they'll want something, either an acknowledged default from the builder or a final arbitration award that says, yes, the builder is liable and needs to pay the owner. These guarantees should always state that they are irrevocable and unconditional. And in addition to refund guarantees, many European builders are owned either by larger companies, larger commercial shipbuilders or diversified companies, or by wealthy individuals. And oftentimes we're able to get either a parent guarantee or a personal guarantee from the yard's corporate parent or beneficial owner. And that obviously gives the owner a little bit more comfort that the builder is actually going to perform its obligations under the shipbuilding agreement. So these are sort of the key questions you want to ask when you're looking at title and security issues with European builders. When exactly can the owner register its interest in the vessel under construction? As a matter of law, that's usually when the vessel's keel is laid, which is not actually when the keel is laid, but when there's a certain amount of steel that's present at the site designated for the yacht. Who pays for the costs, including translation costs if necessary, of registering the owner's interest in the vessel under construction? So in Italy, for example, certain other jurisdictions, in order to record ownership or a mortgage, you have to translate the underlying agreement into Italian, and the costs of a certified legal translation can run into tens of thousands of dollars, so it's nice at the outset if you can get the builder to assume that cost. And then finally, as I mentioned earlier, if there is a refund guarantee, what are the conditions for payment and when does it expire? So banks do not like to give refund guarantees that extend in perpetuity. They like to have a firm end date. And the problem is that you don't know, you can project out beyond the scheduled delivery date and say, well, we have this much time before the refund guarantee expires. But then you have the possibility of force majeure. So what we usually do to avoid having the refund guarantee, if it expires and it's of no use to the owner, what we do to avoid that situation is include as a default provision in the contract the expiration of the refund guarantee, or that it'll expire within 30 days. And that means that unless the builder goes out and gets a refreshed guarantee, they're in default. So that way the builder will make sure that there's a refund guarantee in place no matter how far into the future the delivery date is delayed. A couple things I want to mention about insurance that apply especially for European builders and also just on larger builds generally. Well, the first one actually applies across the board. You want to make sure that the owner is named as an additional insured under the builder's risk policy, so that if something happens to the vessel, the owner can get back what he's paid to date if it becomes a total loss. Or high value items of owner supplies, and that can be anything from tenders to fine art, separately insured. So typically in a European shipbuilding agreement, the owner will agree to insure owner supplies up to some fixed amount, €1 million or €2 million. And above that, the owner is responsible for insuring them. Or if there are individual items that cost more than some fixed amount, the owner is responsible for insuring them. The builder doesn't want to have to worry about the owner's, Warhol or Chihuly glass or whatever. So you just want to make sure that that's covered. Typically, it's picked up by the owner's other insurance policies, but you want to make sure that it's not falling into a gap. And then finally, there are liabilities that you're assuming under the shipbuilding agreement. I mentioned earlier that you often on a larger build will have an owner's representative on site throughout the build. So under the shipbuilding agreement, typically the owner will say that if anything happens to this guy, I'm responsible for it, personal injury or death, something like that. And you really want to take a thorough look through the shipbuilding agreement, see what kinds of liability you're assuming, and then sit down with your insurance broker and make sure that the owner is covered. Because a lot of times people don't think about contractual liability, particularly in the shipbuilding context, but that is something that they should be aware of. So this, it wasn't in the list of provisions that I talked about earlier, but it is something important, so I want to talk about it, and that is the cost of the interior. This is always a big issue, particularly on European builds. In US builds, typically the cost of the interior is just included as part of the contract price. It's a fixed price, it's fully spec'd out. Or if there's a design development phase where the owner sort of collaborates with builder, make decisions about what the interior looks like, and then at the end of that process, they agree on a fixed price. There may be allowances, though, and that's everything from electronics, stone and tile, loose furniture, fabrics, and you need provisions that track those allowance costs. The owner will need notice if he's going to exceed an allowance cost, should get a credit if he goes under the allowance costs. But typically, U.S. builders, there's less of an issue with variable pricing in the interior. European builders, it is much more variable. And there's a few different ways that they can do that. They can establish a standard of finish by using a reference yacht, so the builder's hull number, whatever, we're going to use that yacht as an example, and the interior will be completed to the same standard, quality materials, level of finish as the interior of that yacht. Some builders have a catalog. I think Benetti calls theirs the Book of Excellence, which I kind of like, that has like all of the kinds of wood and tile and fabrics and stuff that you can choose from, and as long as you choose from that book, you stay at a certain price. And then anything above that is charged to the owner as an additional cost. Now, the problem is sometimes it's not entirely clear when the owner is going to be liable for an additional cost, how those costs are measured, and sort of how the whole process works. And sometimes there's ambiguity between the contract and the specification. So the most important thing, particularly on European builds, is you want to be sure that the costs of all items of the interior are clearly allocated. And in many cases, the easiest or the clearest way to do this is to simply have a table with rows of items and columns, things like procurement cost, installation cost, engineering, design, and then in each cell say exactly who's responsible, whether the builder's providing it as part of the contract price, whether it's included in an allowance, whether it's owner's supply. And that way it's some builders call it a demarcation matrix. It's a very clear way of allocating those costs, and it's very helpful in particular with interiors. If there are allowances, you want to make sure that you have provisions saying exactly how those allowance costs are calculated. So for materials, it's usually the builder's actual cost plus some nominal overhead. And then what the rates are for labor, if necessary, you want to fix those in advance. Sometimes builders will want to reserve the right to raise their rates in the future, but that's just something that should be negotiated up front. And then the most important thing, I think, once you've done everything else, is to make sure that the shipbuilding agreement and the specification are consistent. As I said at the beginning, often the agreement and the specification are being developed in parallel, and although we try to keep communication with the builder's the owner's technical consultants who are reviewing the spec, discrepancies always crop up. The agreement usually says that it takes precedence over the spec, but you can always end up in a dispute about whether they're really inconsistent. So it's better just to make sure that there's nothing that could be interpreted as a discrepancy between the agreement and the specification. Taxes. Okay, so for U.S. builders, let's say we're building it in Florida. If the owner is acquiring title to the vessel as the vessel is constructed, the owner can be liable for state sales tax potentially on the vessel. One easy workaround for that is for the owner, to form a new company, register that company as a dealer. That company acquires the boat as it's constructed and then holds it for resale to the owner's actual owning entity. And that final transfer occurs outside state waters. So that's one way you can avoid state sales tax on a vessel that's built in Florida. So for European builders, you're worried about VAT. Goods delivered to a non-EU resident for export generally are not subject to VAT, although there are certain requirements that go along with that. And the builder, because they are liable to charge VAT if it is chargeable, wants to be sure that the owner complies. So that procedure is usually spelled out in the delivery section of the shipbuilding agreement. In most places, the yacht has to proceed immediately to a non-EU port. So in Northern Europe, that's generally Gibraltar. In Southern Europe, that's Montenegro, or I suppose Tunis if you're feeling adventurous. There is one exception. That's something that's happened recently in Italy. We understand that there's a new procedure where you can accomplish an export just by going out to international waters. You don't have to come back with a dock receipt from a non-EU port. I haven't done that personally. Other lawyers in our firm have done that and haven't had problems. The takeaway on this is that particularly on large builds, whenever there's a VAT issue, you want to retain local counsel or a local VAT advisor and get guidance on what the rules are to avoid VAT, because that can be an enormous amount of money. Warranties. Michael Moore's, I think, going to talk about this a little later, so I won't go into too much detail. Under U.S. law, as I mentioned earlier, these are governed by the UCC, state law UCC. There are implied warranties of merchantability and fitness can be warranties for fitness for a particular purpose. Merchantability just basically means, is it reasonably fit for its intended purpose, and does it conform with sort of the general customs of the trade in terms of quality? And those are implied warranties. They don't have to be in writing. The Maximus Warranty Act limits the builder's ability to disclaim implied warranties. So generally, if the builder has a limited written warranty, and all builders do, they can disclaim the implied warranties only by limiting the duration of the implied warranties to the duration of the written warranty. Otherwise, they can't disclaim the implied warranties. U.S. builders often have exclusions for machinery and equipment, things on the yacht that are covered by separate written warranties from the manufacturers. The builder will not agree to service those items. You're sort of on your own to go after the individual manufacturers. We always like to put in provisions because in every case, the builder was the person who actually purchased the component. It's covered by a separate written warranty, so we include provisions that the builder has to assign those warranties and cooperate with the owner to obtain the benefit of those warranties if necessary. So even if they're not assuming responsibility for correcting the defects, whether it's in an engine or a piece of electronics or anything else, they will at least assist the owner in dealing with the manufacturer. More European builders, more European builders than American builders will offer wraparound warranties so that cover everything, including things like engines and electronics that would also have warranties from the manufacturers. And then if those warranties extend beyond the builder's warranty at the end of the warranty period, they will assign those warranties to the owner. European builders more often offer extended warranties on things like hull and superstructure. Oftentimes there's a separate paint warranty that's included as an exhibit to the contract. And sometimes what we've seen, actually I'd say we've seen increasingly, is European builders who will agree to extend the overall warranty on the boat in exchange for the owner signing up to a service plan. So making the yacht available for the builder periodically to inspect, to ensure that their sort of maintenance regime is being complied with. So that's sort of a deal where the owner gets an extended warranty in exchange for giving the builder some access to the yacht and some oversight in their maintenance. So these are questions that always come up when we're negotiating warranties with European builders. One is, when may the owner have the warranty work done at another shipyard if it's a yacht that's built in, say, the Netherlands, but then it's used in the Caribbean and there's an issue down there? You don't want to have to take it all the way back to the builder's shipyard to have the issue rectified. But then the question is, how do you choose a shipyard that's fine with the builder? If you do take it to another shipyard, how much is the builder going to pay? If it's a shipyard, most of the major European shipyards have relationships with yards in South Florida where they know what the costs are going to be roughly, and they're comfortable saying we'll pick up the full cost of the repair. But if it's another shipyard that the builder doesn't have experience with, they are obviously going to be reluctant to pick up the full cost because they have no idea what it's going to be. So typically they will limit it to something like what they would charge, what the builder would charge on an arm's length basis to complete the work at their yard. But that process of selecting yards where repair work is going to be done and determining how much the builder is willing to pay to have that work done at another yard, that's something that has to be negotiated. Sometimes the builder has to send its personnel to the yacht, wherever it's located, to take a look at the problem or install a part. And then the question is, who pays for their transportation and accommodation? So what we usually agree is some area, whether it's the Med in the Caribbean or the Med and the East Coast of the US, where the builder says, okay, if we have to send people there, we'll pay for it. If we have to send them anywhere else, you know, the South Pacific or wherever, you pay for it. So there's typically a warranty area that's a geographic area where the builder is agreeing to send their personnel at their cost to complete a warranty repair. Okay, this I think is the last one. This is law and arbitration, sort of a boring section of the shipbuilding agreement, but also very important. So the first thing to recognize under US law is that a shipbuilding agreement, actually a purchase and sale agreement too, those are not maritime contracts. What does that mean? A maritime contract is a contract that falls within federal admiralty jurisdiction. And if you're in federal admiralty jurisdiction, you have the application of federal maritime law. And a shipbuilding agreement is not considered a maritime contract. And there's no good reason for that, really. It goes back to the 17th century in England. There was a dispute between the admiralty courts and the common law courts over jurisdiction, and the common law courts took back jurisdiction over shipbuilding agreements, and we just sort of inherited that arrangement, even though it doesn't make a lot of sense. But the upshot is that all of these issues, as I mentioned earlier, all of the issues about vessels under construction are governed by state law instead of federal maritime law. We almost always have an arbitration provision. I mean, I know that there's diversity of views about the value of arbitration, but typically it's nice to have some ability to select the people who are going to settle the dispute. You at least know that they're experienced and have some expertise in the matter that's being disputed. You don't have to educate a judge who's a generalist and doesn't know anything about maritime law, much less yacht building. So it's often better to choose somebody who you know has that expertise. There's a couple of arbitration organizations in the US that are good. The Miami Maritime Arbitration Council, obviously based out of Miami, and then the Society of Maritime Arbitrators based out of New York is definitely the oldest and most established US Maritime Arbitration Association. I honestly don't know how much they do with new builds, though. They handle a lot of charter disputes and things like that, and some purchase and sale, but I think they also do a fair bit of work on new build disputes. European builders. Some of the larger ones will agree to English law, whether they're in Italy or the Netherlands or Germany, they'll agree to English law. Smaller builders are less willing to do that. They'll insist on Italian law or Dutch law. You should know that even if your agreement specifies English law, for example, matters related to property in the vessel, where it's actually located, those are going to be governed by local law. So that's why it's important that you talk to a local attorney in Italy or in the Netherlands to make sure that if your client is acquiring ownership of the vessel or if your client has a mortgage on the vessel, whatever the arrangement is, you want to make sure that it's valid under local law, because it doesn't matter if it's valid under English law. If the builder becomes insolvent and suddenly you're in an insolvency proceeding in Italy or the Netherlands, it's going to be Italian or Dutch law that governs your client's interest in the vessel. There's a tendency in these agreements to put London arbitration, no matter what law applies, just because people feel more comfortable going to London arbitration than arbitrating in Italy or the Netherlands. But that often is counterproductive unless the agreement specifically says that it's governed by English law. The reason being that if you have a contract in the Netherlands that's governed by Dutch law and then you have London arbitration, you're now having to hire two sets of lawyers. You have London solicitors to represent you in the arbitration and then Dutch lawyers who know the substantive law who are consulting, and it just quickly becomes very expensive and inconvenient. So unless the agreement is actually governed by English law, London arbitration is usually more trouble than it's worth, and local arbitration is usually fine. I think that's everything I had, so I'm happy to take any questions anyone has about new builds.
On that last slide, thanks. Do you know, is Britain leaving the EU going to have any implication on the British law or English law versus European jurisdictions?
No, I don't think so. I mean, I think English law is still going to be a popular choice for maritime lawyers, and certainly the red ensign flags are still going to do very well even after Brexit. They're very popular. So I don't see a lot of that business leaving the UK. That will obviously affect things like taxes and VAT, and so we'll have to see how all that gets worked out, exactly what the relationship is between post-Brexit Britain and the EU, but I don't think it's going to affect popularity of the UK or London as a sort of a site for maritime law.
In the back.
David, can you talk a little bit more about force majeure and seller or buyer default or builder default, and how and when the insurance company kicks in, and is there any case study you can reference?
Well, let's see. Force majeure, a force majeure clause does two things. It prevents you from being in default if you can't perform because of force majeure. So if there's as we mentioned earlier, a cyber attack and your bank is put out of commission and so you can't pay an installment on the due date, you can avoid being in default if your force majeure provision includes cyber attacks, which many of them now do. The other way force majeure comes into play, which I think is what I talked about earlier, is when you have certain dates, particularly the delivery date, that are fixed in a contract, and you have a force majeure event, those dates can be extended by the period of the event, the delay in construction that was caused by the force majeure, and that's more likely to be something like a storm. Whether there is also damage to the vessel, there doesn't necessarily have to be any damage to the vessel for there to be a force majeure event. If there is damage to the vessel and the owner has to make an insurance claim, one thing that I often see, and I'll mention this, is in insurance provisions, it will say that in the event of a partial loss, the delivery date will be extended by the period reasonably necessary for the owner to make good the damage. Seems pretty innocuous. We already have a force majeure provision that if the cause of the loss was something that was outside the owner's control, then he already has the benefit of the force majeure provision. And if it's not covered by the force majeure provision, if the owner just decided, you know what, I don't like this, let's start over, and burns it down, he shouldn't get an extension. So there's some duplication between insurance provisions and force majeure provisions about how much time the owner gets to respond to something that causes damage to the yacht, and that's something that I'm always sensitive to. But they don't necessarily go hand in hand. You can have force majeure without an insurance claim.
But is there the same attention with the insurance policy? You talked about consistency between the spec and the contract. How important is it to make sure the insurance policy dovetails in there? And is the allocation of risk for force majeure equal between the builder and the buyer?
The risk, I suppose, is equal. I mean, we're talking about events that are beyond either party's control. Usually the contract will say something like the builder has to have a standard form builder's risk insurance policy on terms generally accepted in the Dutch shipbuilding industry. And there's a fairly well understood, well-defined idea of what that sort of coverage means. And you can ask for a copy of their builder's risk policy to make sure that you're covered adequately. But there are some fairly generally accepted guidelines for what's an adequate builder's risk policy. That's a standard form of insurance. And then anything on top of that, you have to negotiate separately. I mean, one example, whatever reason, Dutch yards won't insure war risks. I don't know if they're just not worried about, invasion or whatever, but some clients that alarms them and they want to take out separate war and terrorism coverage. So there's a couple of exclusions like that, but generally when it says, risks generally insured against in the Dutch shipbuilding industry, you know what you're getting.
Hi, David.
Hey.
Outside of what insurance policies may say, is there a clear line for when the risk of loss transfers to the yacht owner?
The contracts generally will have very clear provisions on risk of loss and when it passes. So even if the owner has title to the yacht throughout construction, the builder will retain the risk of loss until delivery, until possession actually passes. And obviously the builder, he likely has a mortgage to secure the payment of the purchase price even if the owner owns the yacht throughout construction, but he definitely has an insurable interest. So he'll typically bear that risk throughout construction even if the owner owns the yacht.
Thank you.
Any other questions? David, would you walk through that scenario once again, avoidance of sales tax in the state of Florida on a new build? Would you walk
Sure.
us through that again?
So this is not something that I've used personally, but it's something that I know Rob has used. And the issue is that if the owner is acquiring title to the yacht as it's constructed, so even if they're not accepting delivery until it's completed, they own the yacht as it's being built. The parts of the yacht are being delivered in the state of Florida, and the owner could become liable for Florida state sales tax on the yacht as it's constructed. A way of avoiding that is to set up a company that enters into the shipbuilding agreement, register that company as a dealer in Florida. So they're holding the yacht for resale and it's exempt from sales tax. And then once the yacht is completed and it's owned by this dealer company that the owner has set up just for this purpose, it transfers the yacht to the actual owning entity outside of the state of Florida. So the sales tax isn't chargeable now. If you plan on using the yacht in the state of Florida, you could still be liable for use tax. It doesn't necessarily mean that you never have to pay tax, but you're building a yacht in Florida, you don't plan to use it here, or you plan to flag it offshore, you have some other way of avoiding state sales and use tax. That's one way you can use to make sure you're not going to become liable for sales tax, even if you're acquiring ownership throughout construction.
Use tax was my next question. Any other questions out here? This is great, good information. Thank you, David.